going to be diving into for long-term care purposes, what the rules around Medicaid are. And they are complex, and it's hard to figure this out on your own. So it can be really helpful to hear those listed off and kind of explain to you before you have to deal with this situation for yourself or for a loved one, or if you are currently dealing with this situation, it can be really helpful to have that information. So before I dive into everything, just a couple quick things. If you should receive a couple things from us at the end of this webinar through your email that you use to sign up. That will be a feedback form as the first thing. So that gives you a place to both give us feedback, of course, but also let us know if you'd like us to reach out to set aside time to talk with one of our attorneys. We do offer initial consultations up for 2 hours, and they are complimentary. So it doesn't cost you anything to come in and talk to us. We ask you to bring in quite a bit of information, but that really helps us give you a good recommendation by the end of that period of time. So if you anything I talk about today raises some concerns for you, or you're dealing with this situation for yourself or a loved one, and you'd like to come in and get advice on those on Medicaid planning or anything like that, please, or even just traditional estate planning, please let us know, fill those out, and we can reach out to you. And then you'll also receive our just a helpful little chart, our long-term care planning pyramid. It's really just the different levels of the pyramid explaining kind of what's important when it comes to Medicaid planning. What factors are more important, things like control or asset protection, things of that nature. And then one other thing, we do have this as an interactive webinar. So if you have any sort of questions that come up as I'm going through and talking, and with this topic, that's completely understandable, please submit them to the Q&A function, and I'll see them come up and answer them as they come in. Just some information for our upcoming webinars too. Next week, we're going to be talking about keeping your gold in your golden years. So retirement account planning and how that ties into your estate plan. So that's going to be our first in this series of keeping your gold in your golden years. And that will be next week at the same time as today. And then our next in-person public seminar is actually on March 15th at the Bordini Center through Fox Valley Tech here in Appleton. And there will be 2 sessions for that, 2 p.m. and 6 p.m. And if you sign up for that, you can do so at estateplanninglive.com or call our office to sign up as well. All right, so to get started, when we're talking about Medicaid planning and just the rules around Medicaid in general, there's a lot of bad information out there online, or confusing information, maybe to put it a little more generously. And so we hear a lot of myths when people ask us questions about Medicaid, of whether that's planning strategies or rules around Medicaid or things they have to be aware of. So I want to kind of go through a couple of those myths first, just to give you an idea of, you might have heard some of these things, and this can really show you that, hey, this might be something I need to be a little more careful on when I'm seeking information, or if I'm doing any planning, making sure I'm not running afoul of anything. So probably the biggest myth we hear, and this is a pretty common one, I think in general, is there's a look back period for Medicaid. And that's true, that's not a myth. But that look back period is 5 years. And we often hear people say, well, is it 7 years, or is it going to be 7 years? And no, there's no talk, at least no serious talk about it going up to 7 years. That look back period is 5 years. And what that look back period means is, if you were to gift money away or transfer assets to protect them within 5 years of applying for Medicaid benefits, Medicaid could give you a penalty for those, the value of those transfers. So it's not 7 years. It's not being talked about going up to 7 years. It's 5 years. But along with that myth around gifting and Medicaid planning and the look back period in general, people often think there's ways to get around that look back period because of certain exemptions that exist under like tax planning law. And so the most common question we get related to how much can you gift in that period of time is, isn't there an amount that the IRS says I can gift to my family members, to people I know, and not have to have that be reportable? And what they're referring to is the annual gift tax exclusion amount, which right now is $17,000 per person. So I could give $17,000 to everybody I know, individually and not have to file a gift tax return with the IRS. But with Medicaid, there is no dollar amount that is just exempt. So that $17,000 gift tax exemption has nothing to do with how much you can gift for Medicaid. So don't gift that amount thinking, oh, I'm getting around this 5-year period of time and it's not going to count against me, because it could. So just be very careful with that and listening to advice on that. And then a really big myth around the home is that regardless of whether you're married or single, that you're going to have to get rid of the home or sell the home before you go into care, because that's what's going to have to be used to spend down on care. And that may not be the case. And I'll talk more in detail on that too, but just know that we hear a lot of people who come in and say, well, somebody told me I'm going to have to sell the home because my husband or my wife is going into care, but where am I going to live then? And that's not something that is good advice. There are exceptions for married couples, so just be aware of that. But to start talking about Medicaid, when we're talking about like Medicaid when someone's going into care, oftentimes people think, well, what about Medicare? I thought that was what was supposed to pay for my stay in an assisted living facility, skilled nursing facility, because that's what we've paid into all this time. But Medicare will only cover rehabilitative stays at facilities up to about 100 days, and they won't even cover the full value of that stay just by base Medicare alone. So once you're past that period of time, past that 100 days, or sometimes sooner if Medicare argues that, well, you're now here permanently, it's not just rehab anymore. Like somebody who has a hip replacement, right? That would be rehab in a facility potentially. Once they argue that and remove access to payment through Medicare, well, then you're privately paying out of pocket. The concern with that is that the cost of care can be very expensive. Just to give you some rough estimates in our area around, the Fox Valley, for example, we generally see like assisted living in the range of, I've seen as low as about $4,500 a month on the very low end, up to about $7,000 or $8,000 a month on the higher end, especially if we're talking about memory care, somebody with Alzheimer's, dementia related care, right? It can be much, much higher on that end. So there's a pretty big range there. And then for skilled nursing, we're often seeing nowadays, $10,000, $11,000 a month, sometimes $9,000 a month, but that's kind of seems to be going away. So care is expensive. And that's where people get concerned about, well, if Medicare is not covering it, and I have limited assets or limited income in retirement, how am I supposed to cover this out of pocket for as long as I need it? So one thing to keep in mind is there are tools out there to help you privately pay as long as possible. Well, one, if you just have high income in retirement and can cover it, that's great. Or if you have enough in assets that you're almost certainly never going to run out for private payment, for example, the billionaires of the world are not going to have to worry about being on Medicaid, for example. But if you have those options available to you, that's great. But if you don't, and you're still concerned about privately paying, that's when you're looking at maybe using something like long-term care insurance as a strategy to help privately pay for a period of time as well. Long-term care insurance is a good tool to use to at least cover a couple years of care. So you'll generally see these policies say they'll pay a certain daily amount, a certain maximum total payment, or for a certain maximum period of time. You'll see a lot of different, caps on things. There used to be these old policies out there that you'd see paid indefinitely and you didn't have to worry about them ever running out. You're not going to find those anymore unless you already have one. And if you do have one of those, don't get rid of it because you're not going to find it again. But long-term care insurance is something that a lot of people are worried about from an expense standpoint as well. And it can be costly to people. But what you want to do is, if you haven't looked into it and you're, anywhere between the age of your 50s to maybe your later 60s at the latest, take a look at it and see what it would cost you and make that determination for yourself. Too many people out there listen to somebody else say, well, it's too expensive for my neighbor, or, this is what it cost them and they told me. Well, this is based off of their health, their age, all these different factors. So just get that assessment for yourself. But then when somebody is not able to privately pay, let's say they've maybe spent through all of their assets or they didn't have long-term care insurance, that's when we're looking at primarily Medicaid to help pay for that stay going forward. One thing to keep in mind with Medicaid is a lot of facilities out there, especially ones with like higher end facilities with more amenities, things like that, are going to start requiring private pay periods. So what I mean by that is they'll require private payment before they will let that individual stay in that facility on Medicaid. So those range depending on how full the facility is, how, I guess, what the care needs might be for that person. And they do vary. We, like at the start of COVID, for example, saw very short private pay periods because they needed people in there. But now that they're getting fuller and fuller, again, that those private pay periods are getting to be a little longer, usually in the 2 to 3 year range for most people. And the reason facilities do this is Medicaid pays a lower rate than a private pay individual would. That Medicaid itself negotiates down. So you want to be able to privately pay for a couple of years because you have a lot more choice in where you're going to be able to go and stay facility wise. You'll have more choice over the amenities that you want in that facility. For example, King, if you're a veteran, they have a bowling alley in their community facilities. If you want that bowling alley and that's really important to you, or you want the private room, or you want the room that has a better view, right? Private payment is going to be very important. So whether that's through your own assets or through something like long-term care insurance, you want to be able to privately pay for a couple of years. But once that period's over, that's when we're looking at Medicaid for a lot of people, just because if they make it beyond that period of time, they often don't have the assets to pay indefinitely. And this all depends on how long they stay in those facilities, what their care needs are, right? What their health needs are, and how long they might live in that facility. But in order to qualify for Medicaid, and Medicaid, those qualifications vary depending on whether you're married or single. You have to be below a certain amount in assets. So this is often where you'll hear people talk about spend down. They're spending down their assets to what they're allowed to keep on Medicaid. And you have to be below your cost of care and income. So if I'm making more in income than my cost of care, I'm not going to qualify for Medicaid. And that's not that hard for most people in retirement to be below that cost of care, because as I mentioned, it can be, on the upper range, $8,000 to $10,000 a month if your care needs are higher. Or more intensive. So it's not hard to qualify for that if someone's going into care. But those billionaires I mentioned earlier, if they're making $20,000 a month, which might even be low, in income, they're not they're not going to qualify for Medicaid going into care because their income's too high. But whether you're married or single, that changes things, because for income purposes, the spouse who's still living at home, they're allowed to keep all of their income, no matter how high it is. So you could be making $20,000 a month as that spouse at home, and your spouse in care is maybe only getting $1,500 a month from Social Security. And if all other things they meet all other qualifications as well, they might still be able to receive Medicaid while the spouse at home is bringing in that kind of money. But if the spouse living at home is not making a certain amount of money, bringing in enough income for themselves, they can keep some of the spouse who's in care, they can keep some of their income in order to continue being able to cover living expenses. The limit on that is they can only keep up to roughly $3,000 in total income in order to be able to shift income over from that other spouse. If they're already making more than that, they won't be able to shift any income over. But in a lot of cases, they can shift some over just to get up to that point. That might still be a pretty big decline in quality of life, though, or being able to cover expenses that they were in the past, because what if that spouse who's in care was bringing in $5,000 a month total, and they were used to living off of close to $6,000 between the two of them? Well, if you're cutting that in half, that could be difficult for them to cover those expenses. And I did just get a question, is that $3,000 per month in income? And yes, it's monthly income that they're looking at in terms of how much you can shift over, not annual income, thankfully, because that would be quite low if that was the case. But the spouse who's on Medicaid, or a single person who's on Medicaid, in terms of what they're allowed to keep for what they call their monthly needs allowance, there is $45 a month in income. So if I'm a single person on Medicaid, all of my income has to go towards the cost of care to supplement Medicaid's expenses with the facility. And I get to keep $45 a month in income in order to cover things that I might need, personally that Medicaid isn't covering. So, a common example I hear is like haircuts or like going out to eat or, just quality of life things that they might enjoy. And whether or not the haircut's an issue depends on the facility. I know a lot of those places have like salons in them and all of those sorts of things too. But that's a common example we hear is what about things like that? And if $45 a month is not very high, that number has not been adjusted for inflation in decades. So it's not high because it was maybe reasonable at one point and now it's just incredibly low. So income qualifications and what the individuals get to keep is going to depend on whether you're married or single and how much income the healthy spouse at home is bringing in themselves. In terms of asset qualifications, though, this is where people are primarily concerned with what do I have to spend to receive Medicaid? What do I have to get down to? And I didn't really mention this earlier, but we often hear it phrased this way, and I just want to make a good clarification that this isn't how this actually works. But a lot of times we hear people say, well, I'm worried about the nursing home taking my assets. I'm worried about the nursing home taking my home, for example. And it's not the nursing home forcing you to like sign things over. They have their monthly costs and you have to pay that monthly cost, but it's not the facilities just taking the home from you. What that is they're talking about what Medicaid is allowing them to keep, what they have to spend down through. So it's not, I want to clarify, it's not the nursing homes like just taking assets from people. They have their monthly cost and you have to pay it. And Medicaid is saying, well, you have to continue making those payments until you're down to a certain point. What you get to keep as a single person is pretty straightforward. You get to keep they won't force you to sell the home, but they can place a lien on it as they provide care. And they, of course, being Medicaid. Medicaid can place a Medicaid lien on the home up to the equity that you have in it. So when your people are talking about the nursing home taking the home, what they're talking about is Medicaid eventually eats up the value of that, whether they sell it during lifetime first or it's recovered against after they pass away. That's what they're referring to with Medicaid or the nursing home, quote unquote, taking the home. So they don't force you to sell the home, but the equity will be used up at some point if you're a single person. You can have life insurance of not more than $1,500, so $1,500 total in face value. If you have more than that, which most people with life insurance tend to, they look at any cash value of your policies that you have as a countable asset for Medicaid. And countable assets just means this is counted towards what you get to keep total. You can prepay burial expenses up to about $15,000 for yourself, for immediate family members, so spouses, kids, things like that. But that's not a hard line number. It's just kind of what people tend to be able to do before it starts getting looked at or questioned by the caseworker for Medicaid on the application. And then you can keep one vehicle up to any value. They don't have a value cap on it. So this is not my legal advice, of course, but my joke is always, if you've ever wanted that Ferrari or that Bentley, that's the time to go do it because they don't care how much that car costs. You can have it up to any point, but that's not legal advice. Don't do that. It's just, a way to look at it of they really don't care what the value of that car is, but one vehicle only. And then they count all other things for that single person, their retirement accounts, bank accounts, additional real estate value, cash value of life insurance, kind of anything that you could get value from. They count all of that, and that single person can only keep about $2,000 in assets. They have to be below $2,000 in assets in order to qualify for Medicaid at that point. So that's also a number that has not been adjusted for inflation in decades. So that's also why that seems so low. So that $45 a month in income, $2,000 in total countable assets for that single person. And then, the home with a lien on it, the burial policies under 15 grand, a car and life insurance under $1,500 total face value before it's exempt. So it's not a lot. And the concern people have with that low number is, well, there are going to be things that maybe I want or are quality of life things that Medicaid may not cover. Medicaid covers the necessities, they cover what you need for your care, but they may not cover the brand of things that you want. They may not cover the type of room that you want or the facility that you want. So you have to be aware that once you're down to that point, your options might be more limited because you have less in cash and you have less in income coming in. This all changes if you're married and one of the spouses is living at home. So the spouse who's a community spouse is what that's referred to, the one living at home. They can keep the primary residence with no lien placed on it. So, this is where I was talking earlier about, we often hear this myth of, oh, you're gonna have to sell your home to help pay for care, for your spouse. Well, no, because it's an exempt asset from Medicaid calculations if the spouse is still living in it, the community spouse. So don't listen to that advice and think, oh, I have to sell my home because this is what somebody told me I have to do. If you're a spouse and you're married rather, and your spouse is in care, you can keep that home, that primary residence, without having to have a lien placed on it, without selling it first to count, have it spent down through for that spouse's care. The community spouse can also keep all qualified retirement accounts that are in their name. So that's things like IRAs, 401ks, 403bs, any of those types of accounts, whether they're Roth or traditional, so pre-tax or post-tax, as long as it's one of those types of accounts and it's in the name of that community spouse, they don't have to spend any of that on their spouse's care. So this can be great or not great, depending though on which spouse needs care and who has the higher value in their retirement accounts. Traditionally, like if you look at older generations going into care, it was primarily the husband who had the vast majority of these assets in their name. And also guys tend to be the ones who need care first or need more expensive care or don't live as long. So these assets were more at risk, but we're starting to see it be a little more evenly split, which is good. But this can be great or not great, like I said, depending on who has those assets and who needs care first. Then the same things apply for that community spouse. If they can keep the one vehicle between the two of them, one vehicle total, they can each have $1,500 face value in life insurance and the burial policies, all of that. But then the spouse at home also gets to keep quite a bit more in those countable assets that I mentioned. So bank accounts, whether they're joint or individual, the IRAs, 401ks of that spouse who's in care. And when we have like cash value of policies, that gets counted and added up as well. So all of those other things, additional real estate, whatever it is that Medicaid says, these are countable assets, you're going to have to spend down some of that. The community spouse can keep no less than $50,000 in those. They won't force them below that point, but they also can't keep more than about $148,000 of those assets. And how they figure out how much of those assets you get to keep is they total it up and then divide it in half. And wherever that half falls, that's what you get to keep. So if that half falls below $50,000, like if I had only $50,000 to start as a community spouse, I'd already have my spouse on Medicaid potentially. But if my countable assets were, over $300,000, I still can only keep up to the max of $148,000. And I did just get a question, what about assets in the name of revocable trusts where both spouses are trustees? So when we have revocable trusts are countable assets while either spouse needs care. Because with revocable trusts, oftentimes the spouses are the beneficiaries of it during lifetime. And what that means is that has to be used for your care. It's an available asset. So whether or not they're the trustees of that trust is less important than whether or not they can receive benefit from it. And with a revocable trust, they can. So revocable trusts are not exempt from accountability for assets when we're talking about Medicaid, whether you're married or single. They do count towards that total, unless the assets within them qualify as like one of those exempt assets, like the primary residence, like I mentioned, or which this wouldn't be the case, but like IRAs of those spouses that are staying at home. With irrevocable trusts, sometimes those are very commonly used to protect assets from care. With irrevocable trusts, though, oftentimes the spouses are not the initial trustees of it, maybe the kids are, and they cannot receive any benefit from it. They can't get the money back out themselves. So because of that, those types of trusts, if those assets have been placed within an irrevocable trust, oftentimes they are exempt from Medicaid availability. But any transfer to an irrevocable trust still counts as a Medicaid divestment, meaning that 5-year look back period comes into play. So if you transferred everything over to an irrevocable trust the day before you went into care, you'd have a penalty period for Medicaid because you transferred things away. One thing with revocable trust that sometimes can cause some confusion is for what's called estate recovery. So with estate recovery for Medicaid is when they keep a running tab of how much they've paid for your care, and they can recover against your estate when you pass away. Irrevocable trusts are exempt from estate recovery, but revocable trusts that were drafted after August of 2014 are August 1st of 2014 rather, are available for estate recovery. So they can recover against most revocable trusts these days. If it was drafted prior to 2014, so prior to August 1st of 2014, it's grandfathered in and could potentially still be exempt from estate recovery, but it's still countable for you during qualification for Medicaid. So while it may be exempt if it's a really old revocable trust from them coming after the estate, after you pass away, it still will count against you during lifetime. So revocable trusts, always available for long-term care. Irrevocable trust, it depends on whether or not the person themselves could receive benefit from it. So I've seen some irrevocable trusts drafted where it says the person could receive income from it, right? Or they could receive principal from it ongoing and direct where those assets went. And that could be a problem for Medicaid if they saw the language of that trust. So when you have an irrevocable trust, you don't generally want to be your own trustee. It's not really good practice, although there are no rules against it. And you don't want to be able to receive those funds back yourself. So somebody else has to be the ones who can receive those funds or the benefit of that trust. Otherwise, it's available for care. So that's a great question. Revocable trusts, not really safe from long-term care, but could potentially be exempt from the recovery after death if they're old enough. But they're not just immediately off the table. So, what we're talking about when we talk about, trusts and planning to protect assets, that's where people say, well, I don't want to spend down to what Medicaid's telling me I can keep. I want to be able to supplement my care later on, potentially, if there's something it won't cover, that Medicaid won't cover. And one really big piece of advice I can give you is, we often get the question of, should I put the home in the kid's name? Should I transfer my assets to my kids? And generally speaking, that's not a good idea to just give those assets over to the kids. There's a couple big reasons for that, and I'm running a little short on time, so I'll quickly run through them. But the biggest is control. When you gift assets over to somebody else, you transfer the home into the kid's name, you have no ownership rights over that anymore. You don't have the rights to make decisions over that anymore without some other agreement in place. So if those kids wanted to charge you rent, or they wanted to evict you from the home or sell the home from underneath you, they could, right? They own the home. It's also really bad tax planning. So when you put the home in someone else's name and they don't purchase it from you, you transfer whatever your cost basis is over to them. So if I bought my home back in the 50s, I'm going to have a pretty low cost basis in it. And then if I gift that over to my kids, they're also going to have a really low cost basis in it. And if they then turn around and sell it, they'll have to pay capital gains, 15 to 20%, depending on their income, on the difference between that cost basis and what they sold it for. So if you inherit property like that, though, you can receive a step up in basis, which means when I inherit real estate from my parents, I would get it at fair market value as my cost basis that at the date I received it. So you can wipe out most capital gains if you inherit property, but if you've been gifted property, that's a problem for tax reasons. But really the biggest reason is anything that happens to the owners of a property happen to that property as well. So if I own a home and it's not my primary residence and my parents live in it, and I get sued for some reason, or I get filed for bankruptcy, or I pass away, my ownership is subject to those liabilities. And that can be a really big concern when people are trying to protect these assets from their care. You're not trying to open it up to a bunch of other liabilities as well. So that could be, like I said, lawsuits, bankruptcy, somebody passing away. And it just doesn't provide any sort of contingency planning for, well, what if something like that happens in the future that we couldn't predict? The benefit of an irrevocable trust over gifting the home to the kids, putting your home in an irrevocable trust, is if it's drafted properly, you'll be given an occupancy agreement, right? Which says, hey, as long as I pay property taxes, utility bills, upkeep of the home, my trustees of that trust can't evict me, charge me rent, or sell the property without me deciding it's okay. So protecting yourself. Most irrevocable trusts for Medicaid planning purposes also receive that step up in basis as well. So they wipe out on your death any capital gains associated with it. And in the meantime, while you're alive and receiving care potentially, your trustees might be your kids, but their personal liabilities are not the liabilities of that trust, because trustees are not owners of a trust. They manage it. They're the decision makers. Your kids as trustees do not own the assets within it. They're just managing it. So if I'm my parents' trustee of their irrevocable trust and I get sued, that doesn't impact them. So it's just something to be very aware of. It's very easy for people to say, well, I'm going to deed the home over to the kids. That doesn't necessarily involve an attorney. It's very straightforward and, not expensive to do initially, but there are a lot of pitfalls with that people just aren't thinking about when they do that. And it's much, much safer to use an irrevocable trust than it is to just gift assets over to the kids. And you still have quite a bit of control over irrevocable trusts, depending on, whether or not you can fire your trustees if they're not listening to you, or how much control you have over changing beneficiaries at death. This is all going to depend on how that trust is written. But when we draft those trusts, for example, we often keep the ability with our clients that keep their ability to change the beneficiaries at their death, so that if they want to make changes to their estate plan, they still can. But like I said, irrevocable trust transfers to them still count against that look back period. So ideally you want to try to do this in advance if you can plan ahead. But for people who don't have that 5-year period of time, what's really important for them to have is really well-drafted financial powers of attorney in particular, because if you lose capacity and you can't sign things over yourself or create this type of trust yourself, and you're going into care or you're already in care, your power of attorney agent is going to need to have authorities to do that if you want to be able to protect assets at that time. So whether or not you are in care now or might be in care down the road, having good powers of attorney in place is essential to keeping your options open. So I'm running over time and I could talk on this all day. So this is a very quick kind of overview of it. It's certainly not as in depth as we could go with it. So I hope I highlighted just how many different rules there are with this and maybe pointed out some of the bad planning advice we hear. But if you do have any other questions or want to come in and talk with one of us regarding this topic, you have a family member who might need care soon, or you're concerned about yourself and your spouse, again, please fill out that feedback form and let us know you'd like us to reach out to you. And again, those initial consultations are complimentary. We do schedule them for about 2 hours. And I hope I'll see you guys next week at our Keeping Your Gold in Your Golden Years, our retirement account talk, and planning around retirement accounts next week at the same time. Or if you're interested, coming to the public seminar on March 15th, which is our big overview of wills versus trusts and Medicaid and the VA benefits that we work with. That'll be March 15th at the Bordini Center here in Appleton through Fox Valley Tech. And those sessions will be at 2 p.m. and 6 p.m. So with that, everybody stay safe with the pending winter storm if it hasn't already started. And I hope to